objections, individualized objections to these?
I don't know that they're individualized, Your Honor. I don't know that they're individualized. No, they're not. They're not individualized.
Is the certificate still in there?
No.
Okay. Right, so I guess that's what I'm getting at.
Yeah, relevance and the prejudice being greater than the appropriate value of any of these photos that are that old. Yes.
All right. Some of the one, well, I guess, all right. Are we going on record? Are you guys ready? We are. Okay. All right, we are now on the record. We have counsel and Mr. Jackson present. We are outside the presence of the jury. We are here to address the photographs that Mr. Jackson wants to offer into evidence, and we addressed this on the record earlier. I think there's a generalized agreement that some of the photos should be admitted, and there's a general agreement, well, a specific agreement that state's not objecting to any of these based on foundation, et cetera. So before lunch, I think the state had P1 through P148, but I understand of those, 11 had already been removed, so there were only, whatever 148 minus 11 is, 137, I believe, roughly. But over the lunch hour, I understand the defendant has further redacted or omitted some of the exhibits and now only wishes to offer approximately, I can't remember, 50 some, but go ahead, Mr. Johnson.
51, Your Honor.
All right, and do you have the numbers of the 51 you want to offer?
I do.
All right, I'm going to ask that you go slowly for both me and Kathy.
So some of these are numbers between numbers. So do you want me to list them individually, or do you want me to, if I say 6 through 10, is that okay?
That's fine, and these are all part of a defendant's exhibit P, correct?
P.
All right, so I think knowing that you could admit the P, so just give us
Okay.
the numbers.
1, 6 through 10, 13 through 15, 24, 25, 28 through 30, 47, 48, 32, sorry about that, 57, 67, 75 through 78, 80, 81, 84, 86, 87, 88, 89, 90 through 92, 94 through 103, 105, 111, 112, 116 through 119, 137, and 148. We believe, Your Honor, that adds up to 51.
I'm sorry, I didn't catch that last part, Mr. Johnson.
I said we believe that adds up to 51.
All right. And just to be clear, at this point, this is all of defendant's exhibit P that the defendant wishes to offer.
In light of what the court has said, we are willing to compromise and offer this and give up our objection to the other photos that we originally planned to offer.
All right. Over to you, Miss. Over to you, Miss Slaughter.
Thank you, Your Honor.
Didn't mean to get you in mid-bite.
That's okay. I apologize. I am making the same objection that I made prior to us taking our break. I did have a brief opportunity to review the additional photos chosen that get us from the 22 proposed by the state to the 51. They're old photos, Your Honor. It looks like they removed the infant stage, but we are still at the very adolescent stage, prepubescent, no facial hair, 10 plus years ago in a lot of these. There's photographs of a dog that they don't own anymore. There's photographs of family vacations that were well over 10 years prior to this happening. If there is any relevance in these additional photos picked out by the defendant, the prejudicial effect of inflaming the passions of the jury and trying to suggest that because 10 plus years ago they had a great family vacation so the defendant couldn't have killed him it's prejudicial. There's limited, if any, probative value to these additional photographs. I think that the state has been very generous in the 22 that we're allowing in without any foundational objections, and that they're more recent in time. But how many photographs do we need of the defendant playing his flute? How many photographs do we need of the defendant in his Eagle Scout or Boy Scout outfits? They're duplicative and old. And for all of those reasons, we don't think that they're relevant, and we do think that they're, if relevant to any extent, that the prejudicial effect outweighs any probative value that these additional 20-some photographs is going to offer.
Mr. Johnson?
Well,
Did you have anything further to say?
I did, Your Honor. First of all, that's what we went through and did, is try to remove like photos of, depicting similar things. What we did for the older ones, they're not little kids, they're not babies, they're younger, but they're family photos. They're pictures of them as a family, which is what we're trying to show here, is that these are family photos. So we endeavored to take out all the little kid baby photos and also anything that was already represented by another photo. Like, so we don't have multiple photos of him in his Eagle Scout uniform. We don't have multiple photos of him playing the flute. So we endeavored to do what the court asked by dropping this down to 51, and it's not inflaming the passions of the jury, and the state doesn't get to pick our exhibit for us. They're not being generous when they say they're only 22. They shouldn't even have a say in this, except to make their objection as to relevance or whatever else. They don't get to pick our exhibits for us, and the idea that they're being generous just blows my mind. So I'm offering this as to respect the court's view of this. I'm giving up an objection to something that I wanted to put in a larger number in. We have endeavored to pare this down, and that's what we've done.
Ms. Slaughter, anything further?
I think that it's just ironic that Mr. Johnston can make those arguments when he literally objected to autopsy photos. Where is the probative value in these? In Christmas photos from 2013 and 2014, I just don't see it. And before the court makes a determination, I'm hoping that you will be provided the photos finally so that you can flip through them and see exactly what photos we're talking about. Because I think that when the court looks at them, you're not going to find the probative value that Mr. Johnston hopes you find in them.
All right. Do you have is the binder full of the ones you want to admit at this point?
It's split.
All right. Can you bring that up to me, Ms. Garner? I mean, I looked at all of them previously, but obviously I can't place a number to an individual photo. All right. Got it. me ask, Mr. Johnson, there's a lot of photos in here, I should say, several of the photos are just of your client individually. I mean, how does that add? Again, I understand why you want them, but, I mean, the family photos, I understand your argument, and I understand the state's position on the argument, but, I mean, there are numerous photos in here that are just of your client. How does that add to the family picture?
They back up our testimony that we've had from people saying that he participated in flute, that he participated in Eagle Scouts. So it's support for those things that we have had testimony for.
Yeah, I don't remember. It started with P1. All right, I'm just going to start. I've got P96 of the defendant and his dog, and then P97, it looks like, with the defendant with his dog. I got two of those. Again, these aren't family. Any particular relevance to these two?
Can I see him, Your Honor?
You may.
Well, the relevance would be, I think the state is trying to suggest through some questioning witnesses that the defendant wasn't close to his dog or wouldn't sleep with his dog. The argument they're trying to make is that he wouldn't be sleeping with his dog on the porch, and that suggestion has been raised in some of the questioning of the state, so that's why those are in there.
I don't recall, I recall that was a potential issue, but I don't recall that coming up at all during trial. Do you, Mr. Shearer or Mr. Slaughter?
I do recall asking one of the state's witnesses one of the defendant's witnesses, if he ever saw the defendant and his dog sleep on the porch.
Okay.
That's the extent of the questioning, and that's not the same dog either.
Right.
Isn't that the same? Can we?
Yep. And while we're at it, here's a couple more. These are P116 and 117.
P96 is the same dog.
Okay.
We withdraw 97.
Okay. All right, so just to be clear, you've withdrawn P97.
Yes, Your Honor.
All right. I've looked at the photos, and again, the state's conceded that some of them should be omitted. It's just really, where do you draw the line on relevance? At this point, are there any other objections other than as noted? No. All right. I'm going to admit P1, P6, P7, P8, P9, P10, P13, through P15, P24, P25, P28, P29, P30, P32, P47, P48, P57, P67, P75, P76, P77, P78, P80 through P81, P84, P86 through P92, P94. I see P95 is just a picture of the defendant much younger standing by himself. I see no potential relevance to that picture. P95, I'm not admitting. P97 was withdrawn. P117, again, is just the defendant and his dog. P116, P96. So I'm not admitting P95, P97, P95, P117, P117, P116, P98. These are all P99, P100, P101, P102. These are all defendant just by himself. You know, there's already pictures of him in Cub Scouts.
I lost you there. I can tell you admitting those or keeping those out.
All of those are out. P99, P100, P101, P102. Again, these are all, those that I just mentioned are all just the defendant standing by himself, either with a flute or Cub Scout uniform. There's plenty of pictures that have been admitted, that are being admitted, that show him as a Cub Scout or with his flute. Same with P05, P11, P112, P18, and P119. Those are all, again, not family pictures. They're either of the defendant by himself or band or scouting. And again, there's already pictures that have been admitted showing those activities. Plus, I mean, the defendant really hasn't articulated relevance. His argument with relevance was that these pictures were relevant to the family situation, and those have nothing to do with that, at least on their face. So the ones that are admitted, do you want me to go through those again? Or does everybody have it? P6.
Would it be easier to go through the ones that are not?
I've pulled them all out.
Because I've lost you.
95, 97, 96, 98, 99, 100, 101, 102, 105, 111, 112, 117, 116 as well, and 119. I've taken them all out of the binder here. So it's just the ones in front, or starting here with P1. All right, anybody have any questions about where we're at this point?
Can we take the chunk out also?
Yep. Just so, can I just give these to you so we just have,
We're taking them back to our office to scan them in.
well, why are you going to scan these in?
No, these.
Yeah, I understand, just so we're,
'Cause
they're not going to show them to the jury now? What's your concern?
My concern is just making sure that we get the ones out that aren't going back or that the jury's not gonna see. And then that way there's no question later if somebody wrote it down right. We know none of the first group is going back.
Yep. Well,
That's fine, I'll carry it across the bridge like that.
I can give you a envelope later, but you'll also need to scan in those others that I pulled out and just gave you separately so that they're available for the record. All right. Are we ready to bring in the jury? So then, when we bring in the jury, Mr. Johnston will offer all of his exhibits. Well, we'll just consider those offered already. Anybody have any objection to that? The ones that I said I'm not admitting, of the ones he wanted to offer, let's just consider those offered, and I'm not admitting them, so he doesn't need to make another offer in front of the jury. Is that acceptable for everybody for record purposes? And then just offer the ones that are in there. State can just say, other than the objection already made, no further objection, I'll admit them, and then we'll go on to the state's witness.
Do you want me to list all the ones that I'm offering?
I'm happy to do it. If you just bring me the binder, I'll just read out the ones that you're offering, and, I'm happy to do it. Well, they'll go to the jury. You'll need to bring them back and scan them, so. All right, are we ready to bring in the jury? Yep. Are they here, Terry? All right, let's bring them in. And who are you calling?
Jeff Holst,
Holtz.
Holst, H-O-L-S-T.
All right, thanks. Good job. We already said that we can reserve that till our record. Yeah, yep, we put that on the record. No, yeah. We reserve that. Yeah. Yep. So, my point would be, talk about after, here we go. All right, ladies and gentlemen, go ahead and have a seat, and hope you had a good lunch. All right, so we have our jurors back. We have counsel, Mr. Jackson, back. At this point, I believe the defendant has some additional exhibits that he wishes to offer. I am going to just go through those. I believe we have exhibit, these are all, start with the letter P. So P1, P6 through P10, P13 through P15, P24, and P25, P28 through and including P30, P32, P47 and P48, P57, P67, P75 through 70, so 75 through 78, P80 and 81, P84, P86 through P80, well, actually all the way through P92, so P86 through P92, P94, P137, and P148. You wish to offer those at this time, Mr. Johnston?
Yes, Your Honor.
Other than as noted, any further objection, Ms. Slaughter?
No objection aside from what has already been made a record of, Your Honor.
All right, then at this time, the exhibits that I just mentioned are all admitted. With that, Mr. Johnson, does the defendant have any further evidence?
No, Your Honor. The defense rests.
All right. Ms. Slaughter, does the state have any rebuttal?
Your Honor, the state would call Jeffrey Holst to the stand.
Good afternoon, Mr. Holst. I'm going to have you come on up here to the seat furthest to my left. Go ahead and have a seat.
Okay, thanks.
Yep. And that microphone's on, so just you can adjust it however you'd like.
Sure.
All right, sir, I'm going to go ahead and swear you in. Mr. Holst, do you swear or affirm that the testimony you'll be giving today in this matter will be the truth?
Yes.
All right, you can put your hand down. And then just for the record, can you please give me your full name and spell both your first and last name for me?
Sure. My first name is Jeff, Jeff. My last name is spelled Holst.
Ms. Slaughter?
Thank you, Your Honor. Investigator Holst, can you tell us how you're currently employed?
Yes, I'm employed with the Cedar Rapids Police Department
And how long have you been employed with the Cedar Rapids Police Department?
since 2005.
Are you a certified peace officer in the state of Iowa?
Yes, I am.
Went through one of the Iowa law enforcement academies?
Yes.
What is your current title with CRPD?
I'm an investigator with the Criminal Investigative Division. I specialize in digital forensics, so I'm a certified forensic computer examiner.
And when you say that you are a certified forensics computer examiner, tell me how one becomes certified as such.
Well, first of all, it's a fancy way of saying I look for evidence in digital electronics, so it sounds kind of like a mouthful, but the training really isn't too bad. It's spread out over a couple years. The first trainings that I go to are through an organization called the National White Collar Crime Center. That training provides locations throughout the U.S. where I go and learn the basics, and then the intermediate, and then the advanced type of topics when it comes to digital evidence. And then I attended the International Association of Computer Investigative Specialists training. That's the certifying body for me. They're an accredited program, and so they certify me, and then I have to recertify every 3 years.
And where's that training that takes place when you're accredited?
That's in Orlando, Florida.
In your professional capacity, what type of cases do you generally work on with the Investigative Bureau?
I work on the Iowa Internet Crimes Against Children Task Force, which is part of a nationwide task force that involves child exploitation, child pornography types of cases. And because of that, I also have technical skills that apply to other types of cases, such as the one we're talking about today.
And how so?
I can examine any kind of electronics, and so even though my primary duties when I go in every day is to look at cases that have to do with child pornography or child exploitation, if there's a homicide, if there's a robbery, a burglary, that type of thing, if there's any kind of electronic device that needs to be examined, typically that is left up to me to do that for the department and also for the surrounding communities.
Can you tell us if in your professional capacity you spend time dealing with a program called Celebrate?
Yes, I have.
Can you tell us what Celebrate is?
Celebrate is a company. They offer several different services. The services that they offer at our department that we can actually touch are hardware and software. So they have hardware that can do extractions from phones, which means pulling the data from phones and other electronic devices. They have software that then processes that data because the data comes out in a bunch of language that we don't really understand. And so the software, they provide software that helps us look at that in a quicker way than we would if we did it manually. If we did it manually, it would take, months to just do one exam, whereas we can do an exam in a shorter amount of time with their software. They also provide labs across the nation where you can send electronics. So if it's something that we can't do in our lab, for instance, if it's a broken type of device, we can send it to their lab and they can help us with those types of things.
And did you receive specific training on how to operate and analyze data that you receive from Celebrite's programming?
Yes, so the training that I go through is, they call it vendor neutral, because Celebrite is just one of many companies that offers those types of services. And so we don't just have Celebrite in our lab, we have different types of companies that we purchase from. And so the training I go to is vendor neutral. It teaches the basics, and I always kind of explain it as they teach us how to do the long division without the calculator. And then the software that we get from either Celebrite or another company does the calculator stuff for us, and then we check it, check your math manually when we find some type of evidence.
When you analyze data that has been received after, I think we've commonly referred to it as a phone dump, when you're analyzing that information, is there a specific process or protocol that you go through every time that you analyze one of those packages of information?
Yes, generally there is.
Can you walk us through, let me ask that better. Specifically in regard to this case, did you look at the phone belonging to Alexander Jackson?
Yes, I did.
Did you look at that phone in an attempt to determine if a specific app related to Ring cameras had been installed or deleted from the phone?
Yes, I did.
Can you walk us through what process or procedure you went through when analyzing that information?
Yes, so, this case obviously happened a few years ago. And so the initial extraction of data, or phone dump as people like to call it, happens right away. And we use specialized hardware and software to do that. That extracts the data out, and then we process it using software. Typically what I do is I produce a report that is easy to see. You can click through it, you can kind of navigate through it sort of like a web page. And I give that to the investigators because they're familiar with the case and they look through some of that content. And then if they have specific questions, such as a Ring app or something else, then they come back to me and say, hey, can you use your training and experience to do a deeper dive on this application and find out more information? And so I first start with the software. The software has a roadmap to help it figure out what to display in front of me. And so it has categories along the side, kind of like a web page. It has navigation. It'll have categories such as application usage or media or internet usage, like power events, different things like that. So whatever you're interested in or whatever you're investigating, you can click on the side and it'll display it in a table in front of you. When it comes to media, it'll display a bunch of thumbnail images for us to look at, just like you would on the internet or on your phone when you're going through your picture gallery. That's the first step, is to look at data that way. And we try to use the software to narrow down what we're looking at. When we find something of interest, that's when the training that I've gone to kind of kicks in a little bit, is I have to make sure that that data being represented by the software is actually what it really is. Because otherwise, if I come to court and testify about it, that could be a really bad deal if the software is showing it incorrectly. And so what I do is I do an extra step of what's called validating the data. So it's forensically validating the data. And in other words, checking your math. In school, you might do a math problem and stuff like that and hand it over to your partner and they check it and they say, yep, you did it right, and so they're checking my work and I'm checking the software's work to make sure that it does it right. And so that's where the rubber meets the road, is you have to make sure that you validate the software correctly, because it can display things incorrectly due to, many times we get software updates on our phones. It happens all the time, actually, for my phone. It's always wanting me to update software and applications. So those can impact how the software works. And so the software that we use to look at the evidence isn't always correct. And so that's why we validate it.
During this deep dive that you did into Alex Jackson's phone, were you able to form an opinion as to whether or not that Ring app was ever installed and/or deleted from this phone?
I have an opinion about it, but I don't know.
So yes, you formed an
Yeah,
opinion.
Yes, I formed an opinion.
And what is that opinion?
The opinion is there's no evidence to show one way or the other. When we find evidence, and I'll go back to what I usually do every day, is I look at pictures and videos. If you find a picture or video, I can do a deeper dive on that picture and video and try to figure out, how did it get there? Did the user of the device, and is there evidence that they knew it was there, or did it just download on its own? That sort of thing. When something doesn't exist, there's no way to prove a negative. We can try, and what I did was I went into some databases and manually went through the databases, and manually went through the tables in the databases to look for evidence of the Ring app, and I didn't locate any. But the problem is that we aren't software developers, and software developers have proprietary ways that they program their software. And so the Ring app isn't going to tell you exactly how it interacts with your phone. And your phone's not going to tell you how it interacts with the Ring app. And so when I don't find evidence of the Ring app, I can't say with certainty, I can't testify with certainty whether it was or was not on the phone.
Was the phone the only device that you checked for the Ring application or accessing the Ring?
There was other devices in the home that we checked.
And what were those devices?
There was three other devices. There was a device owned by the sister. I'm bad with names. Some people might be like me, but I refer to him as the sister's phone, the dad's phone, the mom's phone, and then the brother's phone. And so brother would be the defendant. And so I looked at the defendant's phone, and then I looked at the other three phones, as well as a gaming computer, and then I attempted to look at a laptop computer.
And when you say you looked at mom and dad's phone, you did find evidence on those phones that the Ring app existed, right?
Yes, I did.
And you found evidence that the dad's phone had been accessed on June 13th of 2021?
Yes, and I have some notes I can refer to if you need exact dates and times, but that's correct.
And mom's phone had been accessed, I believe, June 12th of 2021, is that correct?
That's correct.
What about sister's phone?
I didn't see any evidence of the app on that phone.
Now, you said something interesting. Well, you said you looked at a gaming computer, correct?
Yes.
And what's a gaming computer?
It really can be anything, but typically I label computers based on what I find on them. And what I found on this computer was it was a souped-up computer, kind of like a souped-up car, and it appeared to be used for gaming, which is really common these days, and lots of people have them. So it's like a tower rather than having a laptop or something like that. It's a tower. It has extra hardware inside that can handle graphics and things of that sort. And then there was also a lot of gaming information on the computer, which leads me to believe it's a gaming computer.
And then you said there was a laptop that you attempted to look in, is that correct?
Yes, I attempted to do an examination of a laptop that was found in the home, and I was not able to get into that actual laptop.
Were you able to determine who that laptop belonged to?
It appeared to belong to the defendant because it was found in the same area as the gaming computer, but without getting into the actual laptop itself, I mean, I can't say for sure who owns the computer. We don't usually get that far into it unless we start looking at user data and logins.
And you weren't able to get into it?
I was not, no.
Why?
It was encrypted.
What does that mean, to be encrypted?
Encryption just means it's scrambled, and you need a key to get into it. And so really it's more complicated than that, obviously, but really the simple way of looking at it is the data on it is all scrambled, and it's in code. And if you don't have the decryption key, or you don't have the password to open the decryption key, then you can't actually access the information on the computer.
And so regarding the laptop or the encrypted laptop, you were, again, not able to confirm or deny, if that's the word I'm looking for. You couldn't tell whether or not Ring had been accessed from that laptop either.
No, I couldn't access any information from the laptop.
Investigator Holst Is part of this investigation, were you the point of contact for the return of information after the execution of the search warrants?
Yes, for the ring search warrants, I was.
For the ring search warrants, thank you for
Yes.
that clarification.
Yes.
Investigator Holst, my understanding was that there were 2 different warrants served on the ring company, is that correct?
That is correct, yes.
In the second set of data, or the second attempt to receive data from Ring, did you receive information or any additional video clips in that second execution of that search warrant?
No, I did not. The return from Ring indicated that the devices were offline and there was no data available.
Do you know what it means for the devices to be offline?
Yes, I mean, they're not connected to Ring's network, so Ring can't communicate with them, and therefore information can't be exchanged from the devices to Ring where they store it.
When the first search warrant was executed, in order for you to have received that information, does that indicate that the devices were online at that time?
Yes, when we receive information from Ring, we know at least during those times the devices were active and communicating with the Ring's network, because the search warrant is to the servers at Ring. They actually have the data. It's not stored on the devices themselves in the home. And so, yeah, we knew that they were communicating at that point.
To be clear, did you receive any information, though, that explained why that second attempt or that second execution of the search warrant, why the devices showed to be offline?
No.
I don't have any further questions, Your Honor.
Cross-examination, Mr. Johnston.
Hi. Investigator's fine, or you can call me Jeff.
So let's start with what we just finished.
Okay.
So there was a second search warrant served on Ring for an experiment that the officers did in the backyard, is that right?
That's my understanding, yes.
But you got no data from any of the cameras back, is that what you're saying?
That's the part that I do know, yes, is there was no data back from Ring on the second search warrant.
Or any of the cameras?
That's correct, yes.
So all the cameras were offline then?
That's the indication that Ring gave us, yes.
Because I didn't see that anywhere in the report from Ring. So you're saying that you had information from Ring that when you did the second experiment for the 17th of June, that they told you that all the cameras were offline?
That's correct, and I communicated that to the team that was doing the experiment. That's why I said I only know about the data, I don't know about the experiment.
So that means all the cameras, the garage camera, right?
That's correct.
And the backyard camera,
Yes,
and the front door camera?
correct.
All the cameras that were working on the 15th of June, right?
All the cameras that were hooked up to the network were not, or were offline when we did the second search warrant.
But they were online on June 15th, correct?
Yes, they were, because the cameras were online. I'd have to look at the data to say, but whatever Ring returned to us would have a date on it. So I don't recall I know that some of the cameras returned on the 15th, but I don't know if all the cameras were on the 15th. Does that make sense?
Sure. You authored an email, did you not, on June 16th of 2021? You sent to Josh McAlpin?
Yes, I remember that.
And who is Josh McAlpin?
He's a sergeant in the Criminal Investigative Division.
And you wrote, and this is with reference to the first search warrant on June 15th, right? You wrote, the backyard camera only has 2 motion-activated clips, both around 6:30 Monday night. I am waiting on confirmation from Ring that these really are the only 2 clips, right?
Yes, that's what I was talking about, is I believe those clips weren't on the 15th, so that's why I didn't want to testify inaccurately.
Gotcha. Those were on the 14th, right? Those 2 clips.
From memory, yes, I believe so.
Other cameras have dozens of clips, including police activity after the 911 call. This angle doesn't. It is possible they didn't send all the clips or the motion trigger is either set up differently to avoid picking up backyard animals, or is not functioning correctly, right?
That's correct.
That's what you wrote.
That's what I wrote.
And that's why you conducted this test on the 17th, to try to see if there was something wrong with perhaps the motion detector, right?
That's partially right. First of all, I checked with Ring, and they confirmed that there was only those 2 clips, because my email said, hey, maybe we just didn't get all of them. So I checked with Ring to make sure there weren't any more clips, and they said there weren't. I passed that along to the team that was doing the investigation. And then I did not participate in the experiment, so I don't mean to avoid your question, but I had nothing to do with that, so I can't really testify to that.
No, and that's quite all right.
Okay.
But I'm just saying that these were the possibilities that you brought up in your email to Josh McAlpin, right?
Yes, that's correct.
And the reason that you were all wondering about this is because on the 15th of June, all the other cameras showed police activity from that day, right?
That's what I remember, yes.
And the only camera that didn't even show the police in the backyard was the backyard camera, right?
That's correct.
Even though we know that the police were in the backyard that day.
Yes, that's correct.
So it sounds like from your testimony that you would agree that there was no evidence on the defendant's phone that he ever had the Ring app on there, right?
That's correct. There's no evidence on the phone to say whether or not the Ring app was on there.
And you would also agree there was no evidence of the Ring app ever being on the sister's phone too, right?
That's correct.
Wouldn't that be entirely consistent with the fact that the parents set up these cameras and the kids didn't have anything to do with it?
Objection, Your Honor, that one calls for speculation.
Sustained.
So if I got your testimony correct on the, what you testified to about where you did find the Ring app, you basically agree with the person that we had review these, right?
I hesitate to agree to anybody that's been talking, because I don't remember exactly all what he said, so
Well, okay,
if you can help me out, I can try to agree or disagree with something.
You said that the Ring app was last launched on Jan Jackson's phone on 6/13/21 at about 6:20 p.m.
I have my notes. Can I look at my notes?
Sure, please do.
Oh, okay, sorry.
Please do.
Normally, we don't look at notes, but with this kind of stuff, I want to make sure I'm accurate, and I can't remember dates and times that well.
We want you to be accurate too.
Okay. Okay, go ahead, sir.
So would you agree that the Ring app was last launched on Jan Jackson's phone on 6/13/21 for 47 seconds at 6:20 p.m.?
I've got it actually at 6:19 and 11 seconds.
Well, and wouldn't that be the camera photo that was at 6:19?
No, I've got a different time here, so.
Okay, all right, you're off, so you would disagree by a minute then?
Yeah, I'm not trying to split hairs. I'm just saying. I have
no.
from 6:19:11 seconds to 6:19:40 seconds, so that's what I have.
Okay, all right. Same date, 6/13/21,
That's correct.
and roughly at the same time.
That's good, yeah.
And did you note how long the app had been launched for?
Well, between 6:19:11 and 6:19:40, that would be how long
Okay, all right.
the app was open.
So we had 47 seconds, you have a little less than that.
That's correct.
All right. And then, did you note that there was a corresponding still photo on June 13th from the backyard camera at 6:19 p.m.?
Yes, I have it at 6:19 and 16 seconds.
Okay, so you would agree with that too?
Yes.
And you would agree that the Ring app was last launched on Melissa Jackson's phone on 6/12/21?
Correct.
And did you have 8:55 a.m. for that one?
I have it 8:53, but that may be incorrect. I'll go with what you say, that's fine.
And that was active for 24 seconds?
I believe so, yes.
And would you agree that the Ring app does not appear anywhere, we already talked about this, I think, but it doesn't appear anywhere on Alexander Jackson's phone, does it?
That's correct.
When did you do this analysis?
This analysis I looked at just over the weekend because it came up through the prosecution had some questions for me. So, typically I would spend a little bit more time doing this, but over the weekend I looked at it, and that's why I have my notes here instead of in my head.
You obtained the Celebrite data, though. I want to be accurate.
That's fine.
On June 15th of 2021, right?
That's correct.
So if anybody wanted to know whether Alexander Jackson had used the app, they had that information back on June 15th of 2021, right?
Yes, I passed the reports that you can navigate through along to the investigators.
Not only did you have Alex's phone on Celebrite download on June 15th of 2021, but that's when you also had all the other family members' phones downloads available, right?
Yeah, we had all the downloads available within the same period of time, give or take a few hours.
Looks like from your police reports that you got them all on 6/15 of 2021.
That sounds right, yeah.
So you've had all of that time to do whatever analysis you wanted to do about the Ring app. The Cedar Rapids Police Department's had it all that time, right?
Yes, we have.
You could have done this analysis at any time between June 15th of 2021 and today.
That's correct.
And you did it yesterday.
I was asked to do it this weekend.
Would that have been yesterday?
Well, I think we talked about it on Friday and then yesterday. I don't recall, to be honest with you. I know I did stuff yesterday, yes, but the Ring questions started coming up, I think, on Friday, if I'm not mistaken, with the videos.
But it doesn't have to be a question, right? I mean, there are ways that you can investigate this that would tell you whether or not the Ring app was ever on Alexander Jackson's phone, isn't there?
I'm not sure what you mean, sir.
Let me ask you this question. And back on June 15th of 2021, could you have got another similar model phone, downloaded the Ring app onto that phone, deleted it, and then downloaded the Celebrite data from that phone to determine whether or not it would still show that the app had been installed?
That would not be the way we would typically do things, no.
Well, how would you do it then? If you wanted to know if the Celebrite data was, if it could definitively say that something had never been on someone's phone, how would you go about doing that?
Well, that's the problem, is you can't say anything for sure when there's a negative like that. So if I were to do that experiment, and if I were able to get the exact right software from Apple, and the right, which is difficult, but I'm sure for a murder trial we could somehow try to get that, and the exact right software from Ring, because they obviously have different version numbers, and the exact same phone, it's still, all the variables still wouldn't be equal, because of the way that phones work. I don't want to get into the weeds on the technicalities and confuse everybody, but phones work in the background. So things are happening all the time in the background on your phone, and we don't know about it, we don't see it, it's not part of the user experience. And so I couldn't replicate that experiment like you could in high school when you do an experiment where you have, a certain amount of one substance and a certain amount of another substance, and you try to mix them and that sort of thing. Well, you can't do a scientific experiment that would be conclusive by doing it that way.
But you would at least know, if you did that, you could at least look at that data and say whether it showed up or not, right?
It's just not best practice to do it that way.
Well, I'm just saying, are there not ways you can examine that to see whether or not an app has ever been on somebody's phone and then been deleted?
That's what I'm saying, is that I've gone into the databases and manually gone through the databases to look for evidence of the application on the phone, and I didn't find any evidence of that. But what I'm saying, since I'm testifying in court, is that I can't say that that app was never on the phone. There's just no way I can testify to that. That doesn't mean I'm advocating that the application was on the phone. I'm simply saying I don't know whether it was on the phone or not. Now, if it was currently installed on the phone, yeah, we would be able to see that, of course.
I'm sorry, what was that?
If the app was currently on the phone, we would be able to see that. But I just can't say with certainty that the app was on the phone and then deleted, or if the app was never on the phone at all. There's no way I can testify to that.
I'm saying that if you conducted that experiment, at least you could see on that occasion whether or not the Celebrite download showed that the app was ever on the phone or not, right? You would at least have that example.
It's a flawed experiment, so I wouldn't do it.
Okay, all right. And there's no other way you can find that out?
No.
But what you did find was entirely consistent with the app never having been on Alexander Jackson's phone, correct?
No, I wouldn't agree with that. Again, I'm not trying to split hairs and be difficult, but I want to be precise when I testify. And no, I cannot say whether or not it was on the phone and then deleted, or if it was never on the phone, just like I can't say that with the sister's phone.
No, I understand that. I'm saying it's consistent. What you found is consistent with the app never having been on Alexander Jackson's phone.
I can't say that because the measure that you're trying to compare it to be consistent, that measure is unknown. Again, I'm not trying to get into the weeds or be technical about it, but that's just, I just can't agree to that.
I don't have any further questions. Thank you.
Thank you, Mr. Johnston.
Ms. Slaughter, redirect?
No, Your Honor.
All right. Then, investigator, you are free to step down and free to leave.
Thank you, Your Honor.
Thank you. Does the state have any additional rebuttal witnesses?
The state does not have any additional rebuttal witnesses, Your Honor.
Any rebuttal on behalf of the defendant?
No, Your Honor.
All right. So, ladies and gentlemen, every once in a while things go as I expect. And so I think that went kind of like I thought it was going to, and I told you. So what this means is we're done with the evidence in this case. We're going to let you go, as I indicated before lunch at this point. There's some things we have to finalize and take up, and so that we're going to be in a position to, at 9 o'clock tomorrow morning, start directly with me providing you with the jury instructions, or at least most of them, and then we'll go into closing arguments, just so you can prepare for tomorrow morning, or for tomorrow. Once the case has been submitted to you folks, then we do keep you here during the day, right? So there will not be a lunch break. Tomorrow, I would anticipate you will get lunch. We will provide you lunch. If Terry is not already, she'll get a lunch order from you. But you will be here. You will not get to go home or leave once you've begun your deliberations tomorrow until the end of the day or however long that takes. And you'll get further instructions. But I just wanted to let you know that don't plan on a lunch break tomorrow. All right? So, again, this case has not been submitted to you, so keep an open mind. You still have the law that you're going to get, and then the closing arguments of the attorneys. Keep an open mind. Don't make up your mind yet or any decisions. Don't come to any decisions in this case. Don't continue not to discuss this case with anybody. Again, avoid any media coverage of this case. And again, no investigation of any type or research about anything or anybody related to this case. And with that and the rest of the admonition, bid you a good afternoon, and we'll see you tomorrow ready to go by 9 o'clock. Nobody heard anything. All right, go ahead and be seated. All right. We are back on the record. Outside the presence of the jury, we have counsel and Mr. Jackson present. I believe at this point, Mr. Johnson, you wish to make a motion on behalf of your client?
Yes, Your Honor. We'd like to make a motion for a directed verdict or judgment of acquittal on counts 1, 2, and 3, and all of the lesser included offenses. I think for the sake of the record, I have to go through those as well. But the issue that we do not believe that the state has proven is the defendant committed these offenses. So with respect to count 1, murder in the first degree, we do not believe the state that a reasonable jury could find that the defendant was the person who shot and killed. I believe count 1 is Jan Jackson. Do I have the? And also that with respect to the lesser included offense of murder in the second degree, that we do not believe a reasonable jury could find that the state has proved that the defendant was the one who shot Jan Jackson. I believe that that we're also going to be getting an involuntary manslaughter, lesser included offense, and for the same reason there, I believe that the state has not, that a reasonable jury would not find that the defendant was the one who shot Jan Jackson with respect to that charge as well, with the lesser included. I think, are those all the lessers the court's going to be giving?
Nobody's requested anything beyond that, so absent a request from anybody, I'm not going to give any additional lessers.
Just trying to make my record, Your Honor.
Yep.
With respect to Melissa Jackson, which I believe would be count 2, we do not believe that a reasonable jury could find that the defendant was the one who shot Melissa Jackson with respect to murder in the first degree, or with respect to murder in the second degree, or involuntary manslaughter. We make the same argument as to the identity on the lesser included offenses there. And with respect to count 3, we don't believe the state has shown that a reasonable jury could find that the defendant killed Sabrina Jackson and for murder in the first degree or murder in the second degree, or with respect to involuntary manslaughter. The same argument being that we don't believe that a reasonable jury could find that the defendant committed those offenses against Sabrina Jackson, and for those reasons we'd be moving for a directed verdict of judgment of acquittal.
All right, thank you, Mr. Johnson. Mr. Scheer, it'll be you this time. All right, Mr. Scheer.
Thank you, Your Honor. Your Honor, the state would resist the defendant's motion. First and foremost, based off of the reasons the state has previously stated on its resistance, as well as the reasons the court has provided. When looking at this motion, the court must look in the evidence in light of the state. The state has established a prima facie case for each count. Count 1, murder in the first degree. The victim is Jan Jackson. Count 2, murder in the first degree. The victim is Melissa Jackson. And count 3, murder in the first degree, where the victim is Sabrina Jackson. The state has established a prima facie case for each one of these counts based off of the testimony provided, and even in addition with the testimony that the defense has provided. The key sole question here is who was the individual responsible for the shooting on June 5th of 2021. That is a question that should be left up to the jury because it is a question of fact, and there is more than enough evidence for the jury to reach verdicts of guilt on each and every one of these counts based off all of the testimony provided. So for those reasons, and the reasons previously stated by both the state and the court, we'd ask the court to deny the motion.
Anything further, Mr. Johnson?
No, Your Honor.
Mr. Scheer? No, Your Honor. All right, then, I mean, essentially, and I understand, but this is essentially the same motion the court's already addressed, and for the same reasons. Nothing's really changed with the additional evidence. Again, as I noted, this is a circumstantial case, but I do believe the state has presented evidence, when viewed in a light most favorable to the state, raises a jury question about whether or not the defendant was the individual who killed Jan, Melissa, and Sabrina Jackson. And again, it's going to be up to the jury to weigh those circumstances and decide whether or not they find that it was the defendant. Circumstances include, but are not limited to, fingerprints on the gun, Mr. Jackson's location in the residence, and other circumstances as demonstrated by the evidence. And again, viewing all of that, and as I'm required to do at this stage of the proceedings, there has been a jury question raised and substantial evidence justifying an inference of guilt. And for those reasons and the reasons I've previously articulated, the motion for judgment of acquittal is denied. At this point, is there anything else we need to address on the record, or can we just move to an informal conversation to talk about jury instructions, and then maybe either later today or first thing in the morning, make a formal record on jury instructions?
We can move to informal conversations.
Mr. Johnson?
Agreed.
All right. So, jury instructions, couple, I think we talked before lunch about, informally, about submission of involuntary manslaughter. The state's not objecting to the defendant requesting it on client to submit it. And not generate an issue. And with that, I think I did include in what you saw a definition of serious injury. I do need to add a definition of reckless, so I just incorporated the stock jury. You don't have it. Well, I noted I admitted that, but there's the stock definition of reckless, which I will.
I have, with the addition of the serious injury instruction, I have a definition of substantial risk of death that I always include. I can get the citation and the instruction that I've used multiple times in the case that it comes from. But that if we're doing serious injury, I want to include that as well.
All right, if you get that to me, just email that, include that. A couple other things that I just, instructions that I don't have, I'm kind of thinking about. One, there's no, I think, I don't know if you did, but Tyler, I think you referenced or read from depots a couple times. Did you?
Yes.
All right, so I think we would include a definition of deposition testimony and how it can be considered. Would you agree? Would you agree with that?
Yeah.
All right. Then we also have, this is where we have out-of-court statements, other statements that, for example, search warrants, an email that you just read from. Do we need instruction on those? No, they're not inconsistent statements, correct?
I don't think they're inconsistent.
Yeah, I'm just saying, there's no, nobody's requesting any other instruction or anything. Okay, so, are there any instructions other than the substantial risk of death, the deposition instruction that you thought were missing?
No.
Okay, no, all right.
I'll give it a closer
Yeah.
run over tonight, but at this point, I don't think so.
I did change, if you look at probably what you have as instruction number 6. That's the stock instruction on evidence. And on the second page there, I added a number 4. Anything I tell you as part of these instructions is not evidence. There are a couple portions of the instructions where you both agree that they're not evidence, so you have differing interpretations. But anyway, I just want to let you know that that's different from the stock instruction. Just I added that one, number 4 to instruction number 6. And so you have the defendants in. You had issues, just you had minor issues with the 2 instructions dealing with one, Mr. Jackson's out-of-court statements, and then the other about the statements of the officers. Correct? Yes, sir. Other than that, you anticipating or aware of any significant objections you have at this point?
Other than typos, Your Honor?
Yeah, hopefully I've caught some of those myself, but
I just noted instruction number 15 has a double line.
a double what?
It repeats itself
Okay.
in the
Oh, yeah, yeah.
main paragraph there. I think they threw them all, but no start. Has a correction on instruction number 25 that it should be worth referencing the other instructions, 20 through 21, not 18 through 21.
All right.
I actually caught that too.
choose which one.
Serious injury.
Yeah, I've added those.
Okay, okay.
Yep.
And then it ends with a comma instead of a period.
The serious injury, if I cut that out.
Okay, all right.
All right.
Oh, there's one on page 17 of the court's proper instructions.
That's the instruction on the left.
Number 37, second one.
The very top line on page 17 should say home instead of H.
Oh, H space, okay, I get that. Appreciate you pointing that out, because there may be some I haven't got. I'm sure when I read them tomorrow, I will come across one. It's invariable that that happens. Anything else?
All the time.
Anything on the state's end that you have, other than what we've talked about as far as adding, we all agree on the add deposition, but that's going to change some of the numbering. Other than this substantial risk of death instruction, anything else that you think, any changes or issues you have with what we have here?
Doesn't have to change your numbering if you include it with the serious injury one. It's just a proposal.
Yep. Anything else you think of, Mr. Chair, Ms. Slaughter?
No.
Okay, so, Ms. Slaughter, have you got that one? Do you have that one?
Yeah,
Do you know it too?
I'm doing it right now. I'm just getting the citation because you know when you put it in the final instruction, they take your citation away. So I'm trying to pull the citation back up.
And what I'm going to do then is I'll spend, I've got some notes and changes already. I will probably spend the next half hour or so changing these, and then I'll email them to you. And then let's put it on being here at 8:30 tomorrow. And correct on those, but then I really would like to be in a position to just read these right away at 9 o'clock. At least most of them. I'll save that, what I call the administrative ones called after. And you guys think you'll be in a position to rough estimates at this point? Anybody? Who's doing these? Monica and Tyler? Okay. Any rough idea at this point? Either of you?
On how long it'll be?
I wouldn't even guess.
All right.
I'm not even going to guess.
All right. I just thought maybe you've gone through enough. All right. I will plan on taking, though, I'm not going to make, we'll still take a mid-morning break. And so, in my, so.
We want to be able to test out our equipment this afternoon.
We're all, nothing else going on here.
Okay,
So,
all right,
all right?
all right.
So,
I'll email this to you soon. I got it, my site's downstairs.
fine. You could just email it to me now and follow the site.
Perfect. I'll send it to you too, Tyler, so you can see it.
And then, all right. Anything else we can talk about? Oh, and then exhibits. You guys can take them and scan them today. And then, like you guys, for a representative from each side, before we go back should we go through them real quick, or we have to say, let's just do that real quick, so we're all on the same page.
Okay. Do you have our exhibit list?
Yeah, I think that's it.
I got mine too. Where'd my dang on pen go? Did you take my pen again?
No, probably.
Give me a damn pen. Yeah, this one's mine, because it's almost gone.
You ready?
Yes.
Okay, so the states in that gap, one. I don't think you skipped anything, so I've got 1 through 121. And then I've got 122 through 131. And then 134 through 158.
Correct?
I'm sorry, 134 through 145, we'll say. Oh, wait, you're right, no, 134 through 158.
Yep.
And then 160.
And then, yes.
161 to 171.
Yep.
172 through 174.
Correct. That's what I have.
Yeah, I lost you.
And then our court exhibit 1.
Yeah, 172 161 all the way to 174. Does that match up with what you guys have?
Yes.
I'm going to keep track of it. I'll take a look.
All right, so basically I have states 1 through 174 minus 132 and 133.
And minus 159.
And minus 159 for state and offer, yeah. So 1 through 174 minus 159, 133, 132. Okay, all right?
Yeah.
Then on the defendant's end, I have A through K. And then P, all those ones we went through were showed in the book. And that's it.
Do we have more than one court exhibit?
I think the only court exhibit was the exhibit 1, which is the video.
Okay,
Because we made the map into an exhibit.
that's right. Okay.
Yeah, the map
Was gonna be one.
but you guys
Yeah.
rightly agreed to just get admitted. Okay. All right, so it sounds like we're on the same page. And then as far as my plan would be to tell the jury tomorrow, and there's an instruction that says they're gonna have all the exhibits. I think I'm just gonna tell them I'm not sending the gun or the live ammo back. And if they wanna view those, they should let Terry know, and then, they can come into the courtroom and look at it. Does that work for everybody?
Yeah.
I prefer that,
Yeah.
especially not with
All right,
bullets.
sounds good. I'll email those up to you. Friday.
Right? Then we got a real mistrial.
fucking mistrial.